For pronouncement of judgment, item 47.
In view of the discussions made here and above, the present intra-court appeal preferred by the appellant is held to be devoid of any merit, and accordingly, the same stands dismissed.
Okay, good. Adjournment request, if any, from item number 1 to 6. From item number 7 to 13.
Please, your lord. Lordship, in item number 12, lordship.
Say it, madam.
12, lordship.
Pension. Pay revision.
Deeply open.
From item number 14 to 17. From item number 18 to 30, adjournment request. From item number 31 to 38.
Lordship, I beg to mention item number 29, Lordship. Matter may be adjourned for you. Obliged.
This item number 24 to 28 also.
My lord.
That's not been slipped.
My lord, we have the consent from the other side, my lord. We are seeking time to obtain instructions, my lord.
In July,
Obliged, my lord.
all in July,
24 to 28.
all the agenda. Yes,
From item number 39 to 46.
What's in item number 40? I file an affidavit that may be allowed to be called for.
item number 40.
40.
Yes, what do you have filed?
I file an affidavit bringing on record the inquiry report.
Yes, the report of the income
Yes,
tax.
When you have filed?
today, Lordship, actually yesterday could not sub copy.
My lord, some other date may be fixed. After vacation, due vacation.
Much of it.
Then take some minutes.
May I please, Lordship, item number 44, 45, 46, Lordship. After vacation,
44, 45, 46.
Lordship.
What do you want? What do you want?
The Lordship, the after vacation list, after vacation list,
Any objection from the other side? Who is on
other
the
side is it there?
And concept of the appellant is for. Agenda. The side has no objection. It's in August. Yes,
There's an interim, your lordship. Interim is there.
yeah,
There's an interim, your lordship.
Interim order.
interim order is limited or absolute?
Limited.
It's
Is it
limited.
limited or if
It's
it is limited? It is limited, extend it till next year. or-
Any other request?
Yes, may it please your lordship, I beg to mention for listing a matter lordship here, what happened lordship, KW 25 has been listed as item number 20 on 21st/3/2025. Lordship, in this case, I skipped the notice because my name was not reflected in the cause list lordship. So may I pay very urgent lordship?
Then what is the next date fixed by the registry?
After 6 weeks, it is adjourned.
Okay, fine, it will come in the after 6 weeks. We are not going to grant any permission for this listing and the date is already fixed. No,
Next week lordship, any day.
no, ma'am. Yes. next.
Lordship, may it please, Lordship, I beg to mention for listing, Lordship, an appeal which is filed by the state, my lord, against
Get the date from the registry.
Lordship on Friday, my lord, it's an urgent matter, my lord, because there is a
Whatever
stay
the
operating.
urgent matter you,
My lord,
you can
there's a
request
stay
the registry,
operating, my lord.
registry will list this matter.
My lord, for Friday, my lord, day after, my lord.
Make a request with the registry will like. Yes,
Lordship, I pay for listing of the writ appeal, Lordship, next week.
make the request with the registry will list it.
This is regarding non-payment of pension,
Whatever
Lordship.
it may be, please make a request to the
Obliged, sir.
registry will list it.
I'm on behalf of the petitioner, lordship. I have to mention one matter, that is the case is related to Manipur violence.
Yeah.
Yeah, and we have filed this application for seeking permission to file a bail petition. Already, the Supreme Court has passed the order that has been already
And we
uploaded
have
on their
already,
website.
we are in process of issuing an administrative order to all the courts and then look after.
Okay, thank you. God bless.
Daily list for this item one.
Your lordship paying the earlier order passed in this repeat.
That property board PIL
Yes,
pending.
yes, ma'am.
That has been disposed of.
It is still pending, my lord, some cases, my lord, for the same issue, my lord, these are pending before the apex court, my lord.
Section six.
That is why earlier order was passed, my lord, to list better
Section
after.
6, that's where the validity of section 6A was under challenge.
Not
6A of the Citizenship Act.
No, no, my lord, here it is not challenged, my lord. It is,
Here you have asked
it is,
for implementation of
it
the
is-
Assam Accord.
exactly. It is relating to, my lord, the citizenship amendment bill, my lord, first, while it is,
No, it is
this-
essentially with a prayer to issue a direction for implementation of the Assam Accord.
yes.
And
They are.
so far as,
One of the relief relates to, my lord, Citizenship Amendment Act, my lord. This is pending before the apex court.
which is that PIL, sir? Give us the details. We'll mention in the order that this PIL is pending. Because there is no such mention of any PIL, details of the PIL. Which is that PIL?
Yes. Yeah, my lord, relates to Assam Accord, my lord, and it,
Assam Accord, give us the number of the PIL. That PIL,
which is pending before the apex court, my lord.
obviously, sir.
My lord,
This is the statement.
all right, my lord, I will be allowed some time, my lord, I'll give the number.
But who act upon it? Act to tell it. Act needs an affidavit.
So what are your prayers?
My prayer, my lord, regarding mainly, my lord, implementation of the Assam Accord, my lord, clause
As
5
per our-
and
as per
6,
our
my lord.
information- as per
And
Just as per our information, the government has already constituted a commission for
Yes,
that
ma'am.
purpose and that has also submitted a report
yes,
on which the state government has also issued certain instructions for implementation of the, so that is not sufficient.
yes, this is correct, my lord. It was passed, this PIL was filed earlier, my lord. At the subsequent stage, my lord, these were done. And one of the prayer, my lord, relates to Assam, my lord, Citizenship Amendment Act. For that reason, my lord, earlier order was passed by the Honorable Court
But
that
that-
they, after listing of the, the case be listed after disposal of the apex court.
Sir, as per our understanding that Citizenship Act 6A was added, that has already, the validity of the same has already been upheld by the Supreme Court.
Look, it relates to Citizenship Amendment Act, my lord, the Amendment Act, my lord, regarding,
So that is, you have challenged the bill only.
We-
Now it has
at the
become
bills-
an act. It has become an
while,
act.
while it was filed, my lord, this was at the bill stage, my lord.
So now it is an act, sir.
It has become an ex. My lord, I am against some time, my lord, I have no instruction from my client also, my lord, regarding this. So I may be given some time.
Item 225.
Additional affidavit. Yes,
Yes, Mr.
not
Pushpa, you were supposed to file an additional.
Yes, we have filed. It was filed yesterday.
Yesterday only.
We have not got a copy, my lord.
Huh?
We'll take a copy from them, my lord.
Okay.
Recently also, my lord, there was an eviction in a designated vending zone, my lord, in very near.
Let them file their, comes on record. Then standing possible, the GMC has submitted that. An additional affidavit, the affidavit is already filed in pursuance to the time granted by this court on 22/2025. The same is not available on record. Just after 2 weeks. While placing this additional affidavit on record. Yes,
Item 6.
Lordship, I beg to appear for the appellant in the matter. Service is not complete, it seems, my lord, from the last order of the Lawazima court.
we are appealing for one,
For number 1, 2, and 3.
1, 2, and 3.
Take up with your.
As per the Lauzima court report, the notices issued to the respondent number. How many respond? 3 2? No, 4 2?
No, actually, there are quite a few where
Up to 336
Five,
lots.
2, 330.
5 to 336.
Yes, your lords.
क्या लिखा है? 5 to 36 have been, 5 to 336 have been served upon some of the respondents. However, in respect of some of the respondents, the ED cards, the acknowledgement of receipt of the registered AD is not, is still awaited. Stop. It is also mentioned in the, by the Lauzima court that the counsel who was appearing for the for the respondents, public writ petitioner has moved an application before the registry to transfer this writ appeal at Aizawl bench of Guwahati High Court. Full stop. It is stated on behalf of the counsel for the appellants that since the advocate has filed an advocate on behalf of the non-petitioner, public writ petitioners have filed filed an application seeking transfer of this writ appeal to the Aizawl bench of Guwahati High Court from the principal bench. The service of notice upon the unserved respondent we deem to be effective. Full stop. Having gone through the application referred on behalf of the advocate of non-petitioners, public writ petitioners, moved before this court on 10/3/2025, requesting to transfer the writ appeal, this writ appeal to the Aizawl bench. We are of the view that the notice, the notice issued to respondent number 5 to 336 is deemed to be served on them through their advocate. Hence, the service of notice upon the respondent number 5 to 336 is deemed to be complete, is deemed complete. Full stop. Then a counsel for the appellant is directed to survey copy of the writ appeal to the counsel appearing for the for the respondents of the writ petitioners before the Aizawl bench within a period of,
Up to 1 week, lordship.
within a period of 1 week personally, na?
Yes.
You should serve him. Should serve a copy personally to the advocate also within a period of 1 week. Of the application preferred on behalf of the counsel for the respondents, writ petitioners for seeking transfer of this writ appeal to the Aizawl bench will be considered. Will be considered by the registry. By the registry. Yes.
Obliged.
Item 7.
May I please, your lordships? Lordship, this is that matter, the 1993 advertisement, Your Lordship, on the last occasion, Your Lordship raised the concern that what relief can be granted the appellant at this point of time. So I have come up with some judgments, Your Lordship, I'd like to place before Your Lordship, just one judgment of the Honorable Supreme Court.
Main criteria.
Lordship, this is the 2023 judgment of the Honorable Division Bench of the Honorable Supreme Court in Uzair Imran. Lordship, the operative part. Lordships may kindly take paragraph number 20. This is the operative part. May I read it, Your Lordship?
Yeah.
Paragraph number 20. The third respondent, in our view, has been discriminated against and arbitrarily deprived of the fruit of selection. At this distance of time, it would not be worthwhile to order a remand, particularly when the appellant is responsible for the lease being prolonged in excess of 2 decades. There has been utter carelessness on his part in not producing the amendment rules and the gazette notification before the tribunal. The third respondent therefore cannot suffer for such carelessness and has to be given what is due to him. At the same time, we cannot overlook that by passage of time, the third respondent has crossed the maximum age for entry into public employment. He is 50 years old now, and the age of superannuation is reported to be 60 years. In such a situation, we propose to dispose of this appeal by making appropriate directions in exercise of our power to do complete justice between the parties under Article 142 of the
Now
Constitution.
pause here. So we have the power to give such direction under section, under Article 142.
No, my lords,
How this, what is the perceiving value of this judgment?
my lord,
What is the perceiving value of this judgment?
my lord,
Issue order under Article 142.
my lord,
We are not supposed to, we don't have any power, such power as the Supreme Court is enjoying.
my lord, based on this judgment,
Based, what do you mean by, sir, based on how, what is the, is it having any presidential value, sir?
based on this precedent,
Is it a precedent?
my lord, our judgment has been
Is it a law under Article 141?
no, my lord.
That's all.
But the judgment has been passed by the honorable single bench of this honorable court in light of this judgment of the Supreme Court.
Which Supreme Court?
My lord,
Which Supreme Court judgment?
this judgment, in the light of this judgment, my lord, may kindly take this judgment passed by the honorable single bench of this honorable court.
Okay, show us if the single judge is having the jurisdiction under Article 142, will look at it.
My lord, single bench. My lord, may kindly, this is 2023, Khudeza Khatun Chaudhary. My lord, may kindly take paragraph number 9. That is the operative, from there the operative part starts. It is stated that presently the petitioner is aged more than 59 years and she is about to attain her superannuation had otherwise she been appointed. In this respect, so this judgment has been quoted here, Your Lordship. And then at paragraph number 11. The circumstance in which the Honorable Supreme Court had directed payment of pensionary benefit to a person who was denied the legal right of being appointed by following due procedure of law by the state authorities, and by the time the said right is sought to be implemented, the person had already attained the age of superannuation. My lord. But,
That's all?
no, my lord, so the petitioner herein was given pensionary benefit. So I am also claiming the same relief if it's possible, Your Lordship.
Anything else?
No, Lordship, that much only, Your Lordship. I'm just claiming a pensionary benefit at least for my retirement age, my lord.
Without working for a single day. Without working for a single day.
My lord, without working for single day, this petitioner was also given relief.
We can. But we don't come under consideration of the IA number 72. With the delay, control the delay of 62 days in filing the connected with the appeal. It's stopped. The respondents have not seriously opposed the application for conversion of delay, having heard the learned concept of the parties. And after going through the contents of the application, the limit appropriate to condone the delay of 62 days in filing the writ appeal. Hence, the IA is allowed, the registry is directed to immediately register the connected writ appeal. With the consent of the parties, the matter is heard finally.
Obliged, my lord.
Item number 8.
Right, please, Lordship. My lord, this appeal has been preferred against a judgment.
This item number?
It's 8, my lord. Appeal has, my lord, prior to that, there's a leave application which your lordship has granted leave, my lord. And in the leave application, there is an order of a interim order has been issued to me, my lord. Now the appeal has come for admission, my lord.
This is not for admission, it is still in the orders.
They have, all the parties has appeared, my lord.
We have keep this admission and admission.
And
उन लोगों ने टेंडर इशू कर टेंडर इशू करके ये 11 जून का लास्ट डेट था 60 फिर फाइनली इसमें क्या हुआ
Affidavit is filed on behalf of the respondent number 2 and 3.
yes, they have filed, ONGC has filed an affidavit, my lord, to the effect that in view of the order which has been passed by your lordship on 26/9/2024, there's 8 vehicles, out of which 5 of us, my lord, which, my lord, we are not been heard in the writ, that writ proceeding, my lord. And for 3, they have floated tender. Now,
Admission,
my lord,
this rate appeal for admission.
Well, we are also raising this maintainability of this appeal on the ground of suppression of material facts.
We'll hear it.
Yes.
Admission of 2 weeks.
এই কথাটো কৈ দিয়া যে কিয় তাহাঁতক পাৰ্টি কৰা নাই এই কথাটো কৈ এটা সিহঁতে খুব কৈ থাকে নহয় এইটো কথা
Item number 9.
May I plead your lordship?
it is taken.
Lordship, notice
Vakalatama is
the
filed on behalf of the respondent.
respondent number 1 has appeared, your lordship. May I pray that matter may be put for admission hearing? The interim order may continue, your lordship, till date.
Only one respondent is there or?
No, your others are official respondent, your lordship. We have served copy.
That so is filed power on behalf of the respondent number 1. Other respondents are already served. Service is therefore complete. This rate of appeal for admission of 3 weeks.
Lordship, interim order. Lordship, interim order may continue till then.
Yes,
Interim order may continue till
interim
then.
order if any to continue till next week.
Item 10.
And we have served notice through Dusty, my lord. To that effect, we have filed an affidavit within acknowledgement, my lord, at page 6, my lord. It has been received by none other than the proprietor himself.
Page 20. Another is about the contract is handling contract दिया था तो उसमें रिकवरी करना चाहता था फिर मैंने 11 सिंगल जजमेंट नहीं no.
Okay. Then in concept of the petitioner that filed appellant, the applicant has filed an affidavit regarding the service upon the sole respondent or?
Sole respondent.
Upon the sole respondent, stop taking into consideration the same. And the taking into consideration the contents of the additional affidavit and the acknowledgement made by the respondent number 1 himself on the notice. The service of notice upon the respondent number 1 is deemed to be complete. no one is appearing on behalf of the respondent number one. Having heard the learning concept of the applicant and after going through the contents of the application under section 5, the limitation might be limit appropriate to promote the delay of 39 days in filing the connected date of the IA is allowed. Registry is directed to register the connected date appeal and this for admission of the 3 weeks.
Obliged, my lord. Item 11,
Lordship, service completed through Dusty Lordship. Acknowledgement page 9, Lordship.
Only
In
one
our-
respondent is there.
Only a single respondent, Lordship.
एक रिवीजन ऑफ पे तो रिवीजन ऑफ पे इन लोगों ने हम का 2010 रिवीजन ऑफ पे उस पर तब करके इन्होंने एक कंडीशन रखा कि ये वाला केस को विल नॉट बी रिवाइज पेज विल बी इफेक्टिव फ्रॉम 1/10 but the revised pay of the version will be from 31/12/2005 area amount so ये जो रिटायर कर गया है विद इन 2010 उनको नहीं मिले उसके बाद वालों को मिले तो ये दोनों सिंगल केस में उसको लेके होता ये बट इन्होंने बोला है कि आप ये आदमी रिटायर के लिए तो वो नोशन में भी पकड़ जो करता है उसका लीव एनकैशमेंट एंड पेंशन का उसमें ये पैराग्राफ में भी वो
Same of the unless appearing on behalf from the पहले किया था आपने में 159 days का है वो
item 13,
Yes, we are appealing.
Lordship, I'm for the opposite party.
You are appealing for whom?
Opposite party.
Opposite party, which party?
Lordship, sole respondent. Sole.
Sole respondent?
Yes, Lordship.
You are appealing for sole respondent?
Yes, Lordship.
Yes, what do you want?
Yes, Lordship.
What do you want?
We don't have any objection, Lordship. We don't have any objection in condoning the delay.
You don't have any objection. No.
में अच्छी है टोटल It's not even and we ask 45 days to return. This is the 45 days only. That is the only thing. And one single judgment वही करके ये लेकिन But these are as it then whatever has it ये आदमी लोग 95 से people take के बाद एक break देता फिर हम 20 हम do सकते हैं
pursuant to an appearance on behalf of the sole respondent. The application filed on behalf of the application under section 5, referred on behalf of the applicant is not previously approved. Yes, 415 days control.
53.
53 days.
53, sorry.
Yes.
53.
Hello.
Yes,
Item 14.
May I please,
May
your
please,
lordship?
yes.
My lord, I have filed this, I is seeking a small clarification from this honorable court. My lord,
Yes, what do you want?
Your lordship, I'm appealing for the state of Sikkim, your lordship. I need some time for obtaining the instruction, your lordship, in this case.
My lord, I also need some time because
Okay,
I
may I
just got
just-
the copy yesterday only, my lord. I am for respondent number 1 to 10, lordship.
My lord, may I just point out only one thing? If your lordships kindly come to page 108 of the honorable single judge's order. My lord, here, my lord, there was no grievance, no relief sought for.
Yes,
Para 23, my lord, page 108.
yes.
So far as the grievance of the petitioners against the respondent number 456, my lord, we are 45, we were 45, are concerned. In the first instance, they had appeared in the departmental examination year 1997 for promotion from the post of accountants to senior accountants, and were ranked in the first, second, third place amongst 19 candidates in the panel prepared for such promotion. Its circumstances, in my considered opinion, nothing irregular emanates on their selection and consequent promotions. Now, operative portion of the order of the honorable single judge, your lordship will find page 111. Last paragraph.
Yes.
No orders need to be issued with regard to respondent number 456 in view of the foregoing discussions pertaining to their promotions. They are at liberty to approach the state government for state respondents for redressal of grievances. Now, there was no direction, no relief sought for against us. Clear-cut finding by the honorable single judge.
So who
And-
prevented the state government from giving?
Lordship
you
will
other
kindly,
promotion?
kindly have, my lord. Then, my lord, what they have done, they have promoted me.
Yes,
They have issued the promotion order that your lordship will find 3/3/2023, page 118.
yes,
In partial modification of so and so, the officiating promotion in respect of so and so has been withdrawn till final disposal of the writ appeal number so and so before the Honorable Guwahati High Court. My lord, they gave us promotion right order dated, my lord, page 116, 14/2/2023, and we joined by page 117. Then they withdrawn, and
5-year response, how we?
Lord, only difficulty is that, Lord, subject to permit. One of the applicant, he is retiring in the March of 31st of March. And the reason, on which the promotion has been withdrawn is that
Let them file the application, clarification why they have withdrawn this.
they have given the reason, my lord.
Even the reason, whatever it may be.
Page 1, Lord, the government said that we can give them promotion, no problem in that. Lord, the additional advocate general put an opinion. For a moment, if your lordships kindly consider that, my lord. Page 126, my lord.
Yes.
I have perused the note sheets and the observations therein. The observation made by the additional secretary too with regard to not having any implication for confirmation of confirming the chief accounts officer officiating, not having stay and injunction is completely incorrect. In fact, the judgment in which there is no stay by the Honorable Guwahati High Court would go against the department. It is basic rule of law when the matter is sub judice before the court, no action can be initiated by the department. If any officer initiated the file of accounts officer sub judice matter, that officer in person will be liable to contempt of court act and will be punishable for imprisonment. It is further pertinent to bring it to the notice of the concerned authority that 3 officers, namely so and so, we were, my lord, have been promoted on officiating basis, and said officiating promotion letter has been filed by the petitioners involved in the case before the Honorable Guwahati High Court. In my humble request, kindly withdraw the officiating promotion
in order to avoid contempt of court proceeding against the officer from the Guwahati High Court, that further action of the department in the said case, which is sub judice before the Guwahati High Court, would also go against the appeal filed by the state, because the court will perceive the act of the officer is in contempt as against the law, immediately cancel those three.
His opinion is, what they want to say.
There was no stay, nothing, my lord.
That counsel appealing for the respondent state as well as the private respondents raise some time to file their response to the IA number so and so. How much time?
Yeah, also 2 weeks time.
Lordship, I may be given 1 week's time.
Just after 2 weeks.
Grateful, Lordship.
Much obliged.
Item 15.
Deeply.
No, this is the first appeal, IA is relating to minority violation of the honorable court order. That is minority impugn order at page, Lordship case 17 of the IA.
That is actually it. Yes, appellant number 1, 2, 3, 4. To release this उसको हमने stay किया. So they continue therein. 7, 8, 9 Indian after the history of the law single appointment हो गया था. तो आपने बोला कि उनको डिस्कस मत करो, बट उनको कोई दूसरा जगह में ये क्या करता है साहब ये बस मिसिंग तो कुछ in persons of the order connection which was pleased to state the effect of the order relieving the one after but laid down in the interim the essence that is utilized not far away from those in without disturbing the services of the whole area. So in compliance of so the following have continue.
Yes,
My lord, we are agree with this.
yes, they have misinterpreted the order of the court.
My lord, order of the court at page, my lord, 15 and
Yes,
11.
they have misinterpreted that order.
Yes, my lord.
What's the problem?
My lord, problem with Lordship is
This appointment was cancelled by the learned single judge. And we have simply said, okay, continue them
Yes, my lord.
and ask them to give some duties to some other, they 7, 8, 9 at other places.
Yes,
But in place of them, they have granted, given you duty at other places, what's the problem in that?
We are not having any objection, but the thing is that regarding the violation of the honorable court order, my lord. Whenever specifically there is a direction, so this is a interpretation in itself is a own interpretation
Why
in the
you
order.
reply to this IA? Who is appearing for that? How can you do that?
They filed an affidavit, my lord. The CDPO has filed an affidavit.
What about this IA?
Release of his salaries, my lord.
No,
Release of the
release of
second one,
it.
the first one. The order
You are not aware about the
first one.
contents of the IA?
No, my lord.
834. 834. I 834.
Allowing the applicants, my lord, they were
Item number
removed.
15.
Yes, my lord, yes. But they were removed, my lord, they were released.
What's the order of the court? What was the order of the court?
Page number 15. sir. Page number 15.
15.
51 thing.
অনুমতি প্রদান করেছে
No. Please answer. 834. 834.
উল্টা হচ্ছে Yes, my lord, 1, 2, and 3, my lord, the appointments may not be disturbed. What the CDPO says, well, their appointments may not be disturbed. Well, the CDPO says that by notice dated 25/10/24, the appellants 1, 2, and 3 were released from their duties.
No, this is the earlier one. That was stated by the honorable court order in a earlier IA.
That
why
I understand, but this is what they say, my lord, India.
Wow, how can they say that?
This is the earlier one. Probably.
How they are interpreting the order of the court?
Check it.
This was the first earlier.
বুঝছো
That was stated by the.
একটু জানো
Now.
Division
Rectify
bench
it,
is-
ma'am, by the next date. Rectify it.
Yes.
When counsel appearing for the state,
That order is.
directed to file counter.
They are ordering my order also, my lord. It's an-
Your favor, you first sit down. Your favor will see your favor or their favor.
But relating to another IA.
Counsel for the state respondent is directed to file counter to the IA number 834/2025 within a period of 1 week.
Yes,
Just after a week.
obliged.
My lord, there is another IML 315, regarding the salary that is not been released by the Bandra petition.
See,
315.
we'll consider on that day.
My lord.
Then we will clear it. Now,
I have no objection, my lord, is by Ladakh petition. Master bless
we
me.
have objection.
Item 16.
May please your lordship, we have preferred this condemnation application in central excise appeal. The condemnation is delay is of 265 days.
Returnable 6 weeks.
Much obliged, lordship.
For admission, item 17.
May please your lordship. My lord, the breach appeal is against the judgment and order dated 7/2025, my lord. And the matter relates to the settlement of fishery, my lord. And my lord, basically, my lord, that my lord, as per my lord, fishery rule 2005, my lord, the precondition of the my lord settlement is that my lord that they should be belongs to the 100% fishermen. And my lord, this and a division bench of this honorable court also, my lord, in a judgment, my lord, specifically held that, my lord, this is the mandatory condition, my lord. And my lord, in the NIP, my lord, lordship will find in my lord at S41, my lord. There is a specific condition, my lord, that my lord, certificate of scheduled caste certificate of the Moimal community and certificate of being 100% actual fishermen, fish farm owners from the self-help group shall submit the said certificate issued by ARCS of their concerned district. So it is a, my lord, it's a mandatory condition, my lord, as specified in the NIT, my lord. And my lord, subsequently thereafter, when my lord, that comparative statement was prepared, my lord, by the.
Yes, admittedly, they have not submitted the
Yes, my lord.
actual fisherman
Yes, my lord.
certificate.
Yes, my lord. And my lord, then my lord, the district commissioner recommended, my lord, by this communication that, my lord.
But
that-
the fact remains that
Yes, ma'am.
they are operating the fishery since 2015.
No, my lord, it is true, my lord. But my lord, after my lord, after expiry of their settlement or settlement period, my lord, the same, then my lord, it is an admitted fact that, my lord, they have not submitted, my lord, that certificate. And
Single judges admitted that.
And
They have not
subsequent-
submitted, but taking into consideration that they are operating the fishery since 2015, having a certificate of 100% actual fisherman, and later on, after a few days, they also produced a new certificate was found.
And my lord, that certificate is obtained, my lord, after my lord,
Obtained. In fact, their submission is that they were applied.
no,
but
my
they have
lord,
not issued.
no, my lord, it is not correct, my lord. The tender was opened on 10/9/2000.
Point 25 में वो answer page 48 में settlement orders उसमें भी गवर्नमेंट ने यही लिखा है चल रहे हैं settlementism settle with the condition so that it was settlement expectation of the
Yes.
Well, tender was opened on 10/9/2024, my lord, and subsequently they applied for that certificate on 11/9/2024. When they came to learn that, my lord, their tender will be well.
The landed single judge exercise is discretionary power. So this view is also possible. Sir.
My lord,
Every order of the landed single judge is required to be.
no, it is not.
One view is possible, plausible view.
And secondly,
Yes,
my.
Other view is also possible, but. once
And
the-
secondly, my lord, my next of submission, my lord, secondly, my lord,
And another, though it may not be the only factor, the price offered by him is also
yes,
much
yes,
higher.
my lord. But my lord, secondly, my lord, that 100% actual fisherman, my lord, that condition, my lord, so far, my lord,
The
there's a,
only defect which we found that
my lord,
the new certificate or the renewed certificate, they have not submitted in time. Though they were having 100% actual fisherman certificate in relation to that fishery only and operating the same since 2015. A dispute was raised regarding authenticity of that certificate that has been finalized up to this court.
No, my lord, in this manner, in pursuant to this standard, my lord, what certificate they have submitted, my lord, but it is not on, Lordship, kindly, Lord, for a moment, my lord. It was 85, my lord, page number 85, my lord.
Yes.
Yes, may I read, my lord? This is to certify that Mr. So-and-so, so-and-so had a registered society under this office by registration number so-and-so. All the members of the society belongs to scheduled caste community and they are also fishermen, but all the members are physically disabled person as per inquiry report submitted by the inquiry officer and so. And in the footnote, Lordship, kindly see that this has reference to his application dated 11/9/2024. So, my lord, but the two things is there, my lord. The first of all, that, my lord, they are belongs to the scheduled caste community. It is true, my lord. But the fishing is the not only that part is not there, my lord.
They all are fishermen.
All the members of the society
They are
belongs
also
to scheduled
fishermen,
caste
but all the
community,
members are physically
and they are
disabled
also
persons.
fishermen. But,
They
my
are
lord,
also fishermen.
the livelihood of their that condition is not fulfilled, my lord.
Which one?
That, my lord, that fishing is the only source of their income. That part is not there, my lord.
They're this operating this fishery
And-
since 2015 would be deemed that this is the
And-
only occupation.
And
Or
second,
what else? What other occupation? This vocation they are running at present are in discharging.
so that part is not there, my lord. So,
So,
and so far, my lord, our certificate, Lordship, if Lordship can see that it is specifically stated that
your certificate is not at all in dispute, sir. You are 100% actual fisherman.
yes, my lord.
Your certificate.
And my lord, division bench of this honorable court has already held that, my lord, it is a mandatory.
It's a mandatory, but in the facts and circumstances of this case where they are operating the fishery since 2015, having a valid certificate, the only question that they failed to produce a new certificate or renewed certificate. That they have later on produced, the learned single judge has derived that since they are running the fishery from 2015, having a valid certificate, now also they have produced that certificate.
And my lord,
Apart from that, the price offered by them is.
and my lord, the learned single judge relied upon my lord Jagadish Mandal case, my lord, but my lord, and that para 22, my lord, it goes against them, my lord. But that para 22, my lord, my lord, only to accommodate them, my lord,
Discretion exercised by the learned single judge.
my lord, only to accommodate them, my lord, respondent number 4.
Accommodate them.
My
They have
lord.
applied for that, sir. Simply,
My lord.
only to accommodate that, if they have not applied, and then only the fishery was granted to them, we could have gathered the impression that only to accommodate them. This is not
My lord, para 22 in the Jagadish Mandal case is
considered it.
specifically is there, my lord.
It's also
So, my lord, this
the
is my humble
consent of the
submission.
parties, the writ appeal is heard. Finally, an admission is paid by the return.
We are obliged, sir.
Item 18. Well, the reticle is
Your lordship. My lord, the moot question, which your lordship arises before your lordship is whether on a person to stay of a conviction, any disqualification following from that conviction would be operative or inoperative. So, my lord, in my humble submission, it will be inoperative because a three judges bench of Honorable Supreme Court in Lok Prahari's case, the same question was arose and it has been answered, my lord. I would like to place the judgment if your lordship permit me.
So, as per you also matter requires consideration.
Yes, yes.
But, okay, Learned, this writ appeal is preferred on behalf of the state being agreed with the order dated 22nd of February 2024, passed and writ petition number 6682/2022, whereby the learned single judge as an interim measure has stayed the order dated 19/9/2022 has suspended the order dated 19/9/2022 passed by the respondent.
Respondent number 5, my lord.
Respondent number 5. Full stop. By the order dated 19/9/2022, the respondent, the services of the respondents were dismissed in view of the conviction of him by a criminal court wide order dated 3/9/2022 for wide order dated 3/9 by a criminal court additional sessions judge Halakandi, wide order dated 3/9/22 passed in sessions case number 44/2011, convicting and sentencing the respondent for the offense punishable under section 436/34 IPC to undergo rigorous imprisonment for 7 years and to pay a fine of ₹5,000. In default, further rigorous imprisonment of 3 months. Full stop. Being agreed with the judgment dated 3/9/2022, the respondent has preferred an appeal under section 374 CRPC before this court and the learned single judge of this court, while considering the interrogatory application in bracket criminal number interrogatory application in the said appeal, has stayed the operation and effect of the order dated 3/9/2022. Full stop. The respondent has approached the writ court contending that since the conviction of the respondent has been stayed by the appellate court, the termination, the dismissal order passed by the respondent number 5 is liable to be interfered with. The learned single judge, after considering the submissions made on behalf of the respective parties, has passed the impugned order whereby the dismissal order dated 19/9/2022 has been suspended. Learned counsel appearing for the paragraph. Learned counsel for the appellant has submitted that though the learned single judge of this court in criminal appeal preferred on behalf of the respondent has stayed the impugned judgment passed by the trial court in a criminal case, sentencing and convicting and sentencing the respondent, but the reasons for suspension of conviction, but has not specifically stated the conviction of the respondent. It is submitted that the Honorable Supreme Court in various pronouncements has held that the conviction of a accused person can only be suspended at appellate stage by providing, by supplying the reasons. It is by supplying the reasons. Learned counsel for the appellant has therefore argued that the impugned order passed by the learned single judge is liable to be interfered with. Per contra, Mr. Patavdi, learned counsel appearing for the sole respondent, has vehemently opposed the writ appeal and has submitted that once the impugned judgment is stayed, once the judgment passed by the criminal court convicting and sentencing the respondent is stayed, it would be deemed that the conviction of the appellant of the respondent has also been stayed and therefore stayed. And in such circumstances, the learned single judge has not committed any illegality in passing the impugned judgment. Having heard the learned counsel for the impugned order, having heard the learned counsel for the parties, we are of the view that matter requires consideration and admit no need to issue notice to the respondents as parties as the respondent is represented through the advocate. In the meantime, effect and operation of the order dated so. Order dated 22/2024 passed in. Writ petition number 6682/2022 shall remain state.
I'm obliged. Lordship, I may be permitted to file one additional affidavit.
The in the so and so, needless to say, the counsel for the respondent is free to file counter affidavit to the
Deeply.
Highly obliged.
to the writ appeal.
Item 19.
Okay. Nice, that's fine.
So there is a challenge the order dated on the 3/10/2024 passed in OA 28 of 2023 Malad. This is similar to that matter Malad.
List along with
Way number.
point number different.
Item 20.
Due to subsequent developments, my lord, we are redoing the writ appeal, my lord.
Infructuous.
My lord,
Subsequent events.
subsequent developments, my lord. My lord, it's regarding regulation of the Guwahati University employees, my lord, contextual employees. Since, my lord, that regulation process is complete. So, my lord, we are redoing the,
You are withdrawing now.
my lord,
Yes, learning concept of the
appellants.
appellant is on instruction they submitted that he wants to withdraw. This writ appeal dismissed as withdrawn.
Most of them.
Item 21.
Yeah, please, Lordship, Lordship, due to some medical issue, my lord, arguing counsel could not, medical issue, my lord. Arguing counsel could not appear today, my lord. So matter may be adjourned for a week.
Who is not able to appear?
SB Lashkar, my lord.
Concept for the submitted the arguing counsel is not able to attend the court due to medical emergency. Let's start from in the
Most
month of August.
Item 22.
Tender. 4/3/2022.
Yes, sir.
My lord, the notice inviting e-bids was issued on 29/11/2023 by District Collector Tinsukia for grant of.
That has been interfered by the learned single.
No, my lord, that's the question. My lord, very small area. My lord, I will take your lordships. Now, I being the highest bidder, my lord, it was challenged by the respondent number one. Now, the case of the respondent number one is there. My lord, I did not submit the professional tax clearance certificate, then land revenue clearance certificate, the distance from the street to the highway. Now, my lord, all these things we complied, we have given in page, your lordship will find at page 161, 163.
Single judge was of the view that where is the question of re-evaluation without giving opportunity of hearing to the other party. This is what the learned single judge, that's why only interfered.
No, my lord, I'll take your lordship to that. Your lordship kindly come to the finding at page 269.
Yes.
At 269 paragraph 30, my lord, 30.
30, come.
Has your lordship got that?
Yes.
In the backdrop of the above, let this court deal with WPC number so and so. Admittedly, the private respondent hearing, who is also the private respondent number WPC number so and so, did not submit the income tax returns as well as the balance sheets for the relevant periods duly certified by the chartered accountant. The learned senior counsel appearing on behalf of the private respondent as well as the counsel appearing on behalf of the respondent authority submitted that the same has been held to be directory by the technical bid committee. However, a conjoint reading of the extracted clause 2 and clause 6 would show that the requirement of submission of the income tax returns as well as the balance sheet duly certified by the chartered accountant touches on the very eligibility of the bidder to participate in bid process. And as such, in the opinion of this court, the decision of the tender committee to treat the said condition to be directory appears to be unreasonable and unfair. More so when the same tender bid committee has been so hyper-technical in respect to the petitioner in WPC number so and so. At the cost of reputation, this court would like to reiterate that the same tender bid committee initially held the petitioner in WPC number so and so, but technically qualified. Upon re-scrutiny and had rejected on the basis of the bank document furnished did not contain the bank details.
Upon re-scrutiny.
It is pertinent to note that.
Basis of the bank document, it is pertinent to the.
Yes.
Now, your lordship may see, so far the documents are concerned, income tax return. These are, my lord, computer generated and can be verified by the authority, and exactly they did it. They verified, they found, there is no complaint from the tender committee, my lord. Now, your lordship find in a given circumstances, I will take your lordship to a decision of the appeals court exactly on this line.
First of all, justify the rejection of the technical bid of the petitioners in the writ petition. You
No,
justify.
That's the question, my lord. What the appeals court has said, I'll be clarifying within a moment, my lord.
Of the judgment, sir.
My lord, in regard to that, what I say, whether the High Court can go to that extent, because who is the best judge here?
Who
My lord,
is? Who is?
who is the best judge? Because the tender committee, they know, my lord, exactly on that line, and I'm taking to your lordship.
Sir, why they have not given any opportunity of hearing? Tender committee may evaluate a document as per their understanding, no doubt, they have every right. But before issuing, before doing that, why they have not issued a notice to them?
No, no, because of that,
Unilaterally they have done.
no, whether it can be cancelled and drop a new bid process, my lord, that is the illegality is committed.
That is the only.
No, my lord, that's the reason. Your lordship kindly see 2016 SCC, page 818, paragraph, my lord, 15 and 16.
Efron.
I'll take to Eflon, yes, my lord.
There are many judgments are there.
Then after that also there is another decision, I'll take your lordship.
Plethora of judgments.
My lord.
Efron,
Just this 15 and 16 I will read, my lord. We may add that the owner or the employer of a project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its documents. The constitutional courts must defer to this understanding an appreciation of the tender documents unless there is malafide or perversity in the understanding or appreciation or in the application of the terms of the tender conditions. It is possible that the owner or employer of a project may give an interpretation to the tender documents that is not acceptable to the constitutional courts, but that by itself is not a reason for interfering with the interpretation given. In the present appeals, although there does not appear to be any ambiguity or doubt about the interpretation given by NMRCL to the tender conditions, we are of the view that even if there was such an ambiguity or doubt, the High Court ought to have refrained from giving its own interpretation unless it had come to a clear conclusion that the interpretation given by so-and-so was perverse or malafide or intended to favor one of the bidders. These was certainly not the case either before the High Court or before this court. Now, your lordship will find that the tender committee has accepted it, and this is the computer generated matter, and they have verified on online, and it is easy to verify. Now,
Can be said that it is a case of malafide where their bids were rejected without providing any opportunity. of hearing.
Learned single judge did not give any finding that it was vitiated by malafide or arbitrariness. The next decision, your lordship can see 2023 6 SCR 695. The relevant paragraph, I will take your lordship to paragraph 47 onwards.
There are so many other judgments are also in between 16
This is a fitted one, your lordship will find. Paragraph 47, my lord. Having heard the learned counsel appearing for the parties and having gone through the materials on record, the only question that falls for our consideration is whether the High Court, after upholding the disqualification of Tata Motors from the tender, was justified in undertaking further exercise to ascertain whether EV also stood disqualified and that best in its discretion may undertake a fresh tender process.
You're right up to this extent that Leonard Single Judge should not evaluate your technical bid.
Exactly.
While considering the question of rejection of the technical bid of the petitioners. That's right, that may be one of the things, but so far as regarding this finding of the Leonard Single Judge, para number 28.
My lord, if I take your lordship to the tender documents, if there is a minor irregularity, my lord, the tender committee has the power to ignore that. And that is called waiver power.
That is in relation to your. We understand that is in relation to your para number 28 of the judgment.
Yes,
What is the answer to that, sir?
I'll just for a minute, my lord.
What is the answer to that?
That your lordship want to say that the petitioners were never informed the deficiency they did have.
And that is also, they rejected their bid on the basis of a clause where this deficiency was not at all there, sir.
Then, my lord,
In
one
the
thing,
instead case, what is seen that in spite of the fact the petitioner number so and so were informed their bid were technically accepted and finally opened on so and so, on 22nd of February, the respondent authorities overturned the said decision, thereby rejecting the petitioner's bid. That too on a condition which is not a part of clause 6 of the bid documents.
then my lord,
Additionally, the petitioner was never informed deficiency into so and so. That can be gone into by the learned single judge. Can't ignore this, the clause 6, there is no such condition. And they are rejecting their technical bid on the basis of that there is a condition.
even my lord, without setting aside the entire bid, it could have been, the tender committee could have been asked that give them a chance.
One of the not in this case.
No, so far, my lord, 2023 Tata Motors case, that squarely covers this case.
You want us to finally hear the matter or any other date? Because today, in fact, we remember that one application was filed on behalf of you in respect of the new tender. which has been finalized, I think so on 4/3/2025
The
itself.
bids open now.
You have filed this IA,
Yes, yes.
that is in relation to the new tender.
Yes,
for the
yes.
stay of that.
I have received the instruction that the technical bid has been opened in this new tender.
Financial bid, my lord, in that new tender, financial bid is yet to be opened.
Then observe that any further process will remain subject to the outcome of this writ appeals.
If your lordship keep on, my lord, staying for the time being, my lord, that new process. Otherwise, entire, my lord, by rate appeal will become infractuous.
Then we are not-
Till the date your lordship hear the matter, that
Who
is
is appealing
sometime.
for the this private respondents here? Who is appealing for the private respondent?
Mr. C. Sharma, he appeared in this case, but now I find he is not present.
C. Sharma.
Chinma Sharma.
Also, nominated C. Sharma, respond number 1.
Okay, we are passing it over for the time being.
Well.
Item 23.
Yesterday, we have filed one affidavit regarding your revocation of
When?
parking trust. Yesterday, Lordship.
Now, what is your stand?
Lordship, our stand is Lordship due to insufficient parking facilities. Lordship yet to revoke by the managing municipal board, Lordship.
Yet to be revoked.
Yes, Lordship.
You are for?
I am for Deputy Commissioner Lordship. Information has been given by municipal board Lordship. That is under their control
Who
Lordship.
is appealing for the municipal board?
No, no one.
The big thing. User. Yeah, the principal code.
The inspector of schools ने district commissioner Sonitpur.
Yes. But it is under control of municipal board Lordship. So this has not.
Answer. 7, 8, 7 and 8. Oh, 7 and 8, sorry. 8, 8, just which are both which are then. What of the money? Thank you, sir. Thank you, sir. Thank you. Thank you. Thanks, Teresa. The deputy commissioner should take a call here. He's the main man. Best music. Yeah, that's what I still for me already. No, but still here, there's no way.
When council appearing for the state, for the district commissioner, Punit Roy, has filed an affidavit stating that the decision of using playground of Tezpur Academy Higher Secondary School for parking is yet to be revoked by the Tezpur Municipal Board. Stop. Despite service of notice upon the municipal board, none has appeared on behalf of none has appeared on behalf of them. Having heard the concept of the parties, deem it appropriate to admit the writ petition, this PL petition. In the meantime, the respondent the respondent municipal board is directed not to allow the play school, the playground of the which school?
The school's a play school, academy school. It's school academy. It's school academy school.
Playground of the Tezpur Academy Higher Secondary School. For parking. Till final disposal of this PL petition.
Your Lordship, in the meantime, I may be allowed to file reply to those affidavits.
It's always open.
Obliged.
Item 30.
My lord, this PIL, my lord, virtually for a direction for compliance of the earlier order passed in the other PIL, my lord. In the same type of, my lord, PIL, this honorable court, my lord, passed an order to file appropriate case, contempt or whatever may be for implementation of the
Earlier order was of the year
2021, my
2021.
page 133, my.
May I submit one thing? Kindly peruse page 138 laws.
What?
38 laws.
38. Yes.
Paragraph 16 laws.
Read.
There is a certain observation by this honorable court lordship in paragraph 16 lordship. In the other set of PLs, that was not there. Lordship. So we have approached by filing contempt petitions in the earlier two PL lordship. Let them file affidavit.
What is the prayer?
Lordship. Prayer part is a page in Lordship.
47.
Oh, it starts from 47, Lordship.
Read.
Lordship to direct the respondent authorities to initiate an inquiry in the matter of huge financial embezzlement during the course of implementation of various schemes under the Directorate Welfare of Tea and XT Garden Tribes Assam for the period from 2011 to 2018 in terms of the order dated, Lordship. In terms of the order dated 29/21 passing so and so. To identify the government officials and other persons involved in misappropriation of government fund and thereafter launch appropriate proceeding for their punishment and also for recovery of the misappropriate government fund from them. And to direct the respondent number 2 to do the needful in terms of the directions contained in the order dated 29/21 passed in PIL number 58 of 2021 and or pass such other orders as the Honorable Court may deem fit.
So essentially, and what is the material in support of your this claim? What material you have
It is
placed?
already reflected in the order, Lordship,
Which order?
previous order, Lordship.
What is that?
Page 135.
Read.
Various allegations of financial irregularities, misappropriation of funds, etc., have been highlighted in this petition. These allegations are based on certain reports, inspection reports prepared on accounts of the Director of Welfare of Tea and XT Garden Tribes, Assam during the period of November 2011 to February 2018, prepared by the Office of the Principal Accountant General Audit Assam, consisting of as many as 5 sub-inspection reports, copy of which have been annexed in this petition. It may not be necessary to go in detail the various financial irregularities pointed out in the said inspection reports. Suffice to mention only a few for the purpose of disposal of this petition. At first report annexes Annexure C relating to the period from November 2011 to November 2012 in respect of the said directorate. Irregularities to the extent of rupees 57.95 lakh have been pointed out in the matter of implementation of scheme providing financial.
That this 2011 to 2018, that you have raised certain objections. Now here in this petition only 2018 to 2021. Now you have come with the new plea, na?
Lordship.
11 to 2.
In that petition, similarly in respect of you have raised the allegations regarding certain irregularities.
Lordship.
From 2015, 2011 to 2018.
Lordship.
And here in this petition, you are saying 2 to 2000, this 11 period from 11 to 2018 in terms of the order dated so and so. Okay,
Lordship.
same.
Same, Lordship.
So as per you, some misappropriate, the funds have been misappropriated by some persons or government officials and so and so. So naturally, it's a criminal liability or criminal act on the part of them, na?
Lordship, thereafter, what has happened, Lordship? Kindly peruse 137, Lordship.
Yeah,
Paragraph 14, Lordship.
yes.
In view of the above submission meant, we are of the view that since the petitioner had submitted representation to the authority as mentioned above, we would direct the authorities to examine the same in view of the irregularities pointed out in the said reports. These reports been prepared by the competent authorities of the Office of the Principal Accountant General Audit Assam deserve serious consideration of the authorities, and accordingly we dispose of the PIL with the direction to the respondent authorities, more particularly the respondent number 2, to consider the representation submitted by the petitioner on the basis of the materials so submitted and to dispose of the same in accordance with law after giving an opportunity of hearing the petitioner by passing a speaking order, by causing an inquiry as directed above, and take necessary preventive, remedial, and punitive actions wherever necessary. It is also made clear that while constituting the committee, care must be taken to ensure that the officials who are members of the committee are not the ones against whom allegations have been made. The aforesaid exercise shall be undertaken by the respondent authorities.
Council, so basically your argument is that certain officials have misappropriated the government funds.
Yeah.
And indulged into this criminal act as well as the offences under the this Prevention of Corruption Act.
Lordship.
So why don't you file a complaint?
But thereafter a
Why
committee
don't you
was
file a
formed.
complaint before the criminal court, taking cognizance, because you can always file a complaint.
Lordship, previously we have filed representations, Lordship.
Representation to whom? The chief secretary.
No,
And
Lordship.
if they have not done anything,
No,
if they have not done anything, then what is the courts available to you?
No, after this direction, after the directions of this honorable court, Lordship, thereafter a committee was constituted, Lordship.
Fine.
Lordship, there are, but
Despite that committee report, nothing has been done.
nothing has been done, Lordship.
Then approach the criminal court for taking cognizance against those persons who are guilty.
No, as per the directions of this honorable court, I have approached this honorable court again, Lordship. Since the
Okay.
committee has not done anything,
But
Lordship.
suppose again we will direct them, you take action, what action they will take?
Lordship, at least the committee, their directions which were, the directions which were
The
directed.
Honorable Supreme Court has clearly held that in such type of cases where the allegation of misappropriation fund or there is some criminal act or the complaint regarding the commission of offences under Prevention of Corruption Act, the proper course for the person to approach the criminal court by filing a complaint.
Lordship, we have approached the superintendent of police also, Lordship, kindly pay.
Then suppose if tomorrow you go to the superintendent of police and file a complaint, and if he has not take any action on that, what is the courts available to a common man?
He will have to file complaint.
File complaint. Here also, you are complaining. File a complaint, the law will take its own course.
An observation may be made.
What observation? You withdraw it, will grant you the liberty to approach the criminal court. By filing appropriate complaint.
That are, put the documents that are placed before this honorable court.
Documents you are having, sir, you please submit them
Lordship.
before the authorities concerned.
Lordship.
Look here. This PIL petition is filed by the petitioner. Essentially, with a prayer to direct the respondent authorities to initiate inquiry in the matter of huge financial embezzlement during the course of implementation of various scheme under the Directorate Welfare of Tea and ex-Tea Garden Tribes, Assam, for the period from November 2011 to February 2018. It appears that the petitioner has earlier also approached this court by way of filing a PIL petition number 58 of the 2021, praying similar relief, and this court has disposed of the said PIL petition while order dated 20th of September 2021, directing the respondent authorities, particularly to the chief secretary, to the government of Assam, to consider the representation submitted by the petitioner on the basis of the material so submitted and to dispose of the same in accordance with law, after giving an opportunity of hearing to the petitioner by passing a speaking order, by causing any inquiry as directed above and taking necessary preventive, remedial and punitive actions wherever necessary. Stop. This court has also issued a direction to the respondents to constitute a committee for examining the complaints filed by the appellant, filed by the petitioners. The learned single judge, this court has kept, while disposing of the said PIL petition, has kept it open for the petitioner to again approach this court if they are aggrieved by any action or non-action on the part of the respondent authorities. Stop. Pursuant to that, in Pursuant to the said liberty, the petitioners have again filed this PIL petition complaining that the order earlier order passed by this court has not been complied. So, during the course of the argument, learned counsel for the petitioner has frankly admitted that the complaint filed on behalf of the petitioners is regarding the criminal acts of certain persons who were indulged in embezzlement of the public money while implementing the various schemes of the state as well as the central government. Full stop. He has also submitted that the petitioners have a remedy of approaching the criminal court along with the relevant material for taking action against the guilty persons. Full stop. At this stage, the net concept of the petitioner plays that the respondent authority be granted liberty through its representative to move and to avail appropriate remedy for taking action against the guilty persons under the Prevention of Corruption Act as well as under the provisions of BNS, Bharatiya Nyaya Sanhita. CRPC oblique Bharatiya Nyaya Sanhita. In view of the above, this writ petition is disposed of with liberty as prayed for by the counsel for the petition.
Item 31.
My last occasion, my lord, the other side taken time to file affidavit, my lord.
No such affidavit is filed.
No such affidavit.
Who is appearing for?
James.
Yes.
My lord,
Who's on
private,
time or who's on time?
My lord,
Private respondent.
private respondent, man. They
One
take
to
time.
20.
Name shown, my lord. Police, my lord.
Mr.
They respond on 10/2/2025, council appearing for the respondent number 123. 1 to 23 days for some time to file the counter affidavit and the same was granted. Till date, no counter affidavit is filed on behalf of the respondent number 1 to 23. In the interest of justice, more opportunity is granted to do the needful. List after 6 weeks, interim order passed by this court on 4/11/2024 shall remain in currency till next stage.
Deeply obliged.
Item 32.
My lord, in this case, my lord, I am for the respondent one, my lord. So my affidavit is prepared, my lord, within 2-3 days, I'll file, my lord. I mean, 3 days time.
The next council appearing for the sole respondent is some more time to file.
Their voice service.
Counter affidavit time period for is granted after 10 days.
Voice service.
Item 33 and 34.
Lordship, this is a matter relating to non-granting of benefit to staff nurses having diploma, my lord. Lordship, Health Department has filed an affidavit. There's an order from this honorable court dated 21/2025, wherein the order has been made to tag along with WPC 2974/2020.
That has not been
Lordship, yes, Lordship, unfortunately, 2024 matter has been tagged. 2974/2024 has been tagged by the registrar.
What's the actual number?
2974/2020.
2020.
Lordship, All Assam Nurses Association versus State of Assam.
the order is. It is pointed out by the learned counsel for the petitioner that on 21/2/2024, this court has ordered for listing this writ petition along with writ petition number 2974/2024, whereas the writ petition number 2974/2020 is the matter in which similar issue is raised. Stop. In view of the above, it is ordered that the writ petition number 2974/2020 be detached from this writ appeal, from this writ petition, and the writ petition number 2974/2020 be attached with this writ petition list after. How many?
Any day they filed an affidavit in our favor, my lord. Government
That
has
is the
filed an
medical
affidavit.
department.
Yes, Lord.
Education department,
Finance
health
Department.
department.
Finance department is opposing you.
Oh, I have not got that affidavit.
In that 2974/2020, the
My lord.
finance department is opposed. Medical department is.
Yes.
Sir,
Lordship.
Mr. Nayak. You are from the finance department. In relation to one case where there is the issue regarding disparity between this nurses, diploma nurses and the BSc nursing degree.
Yes.
That is there. You have filed your response on behalf of the finance department,
In that, in another case also not filed here.
2974/2020.
Yes.
File this, your response in this writ petition also, similar requirements is raised. Along with 274/2020. Mr. P. Nayak, the council appearing for the finance department in 2974/2020 is also directed to accept notice of this writ petition also. Here the finance department is party.
Yes, my lord.
On behalf of the respondent number 4.
Hmm.
On behalf of the respondent number 4. The copy of the writ petition be supplied to Mr. Nayak during the course of the day. He may file his counter affidavit. Yes, well. Counter.
3 weeks. After that.
3 weeks.
Health department has filed an affidavit in the other matter, not in our matter, but they say that they'll be relying on same affidavit.
They have already recommended,
My lord.
but they are objecting.
Lordship obliged.
Item 35.
May take up for the time being, my lord, my senior, my lord, surgery is coming, my lord, on that day, your
Mr.
lordship
Perry,
heard this
Mr.
matter.
Perry, Mr. Kumar,
Mr.
you are appearing
Yes, sir.
here.
My lord,
You are in receipt of this.
my lord.
Appeal.
Yes, my lord.
What do you want to say?
My lord, the order passed, my lord.
There are 30, 28 or something.
File your response.
Yes, my lord. We'll file the response.
Then consider Mr. Kumar appearing for the respondent. Mr. Datta appearing for the respondent.
For PNRD department, my lord.
Panchayat and Rural Department.
Yes, my lord.
Face some time to file counter to the writ appeal. Time period for is under how much?
My lord, 3 weeks time may be granted.
3 weeks.
Highly obliged.
Item 36.
My lord, in pursuant to the order the 12/2/2025, my lord, and this affidavit has been filed, my lord. Now they stated that they have taken some steps, my lord, regarding, my lord, and see there, my lord. Affidavit আছে, my lord.
additional affidavit is filed on behalf of the Deputy Commissioner, Kamrup Metro, on 11th of March 2025, wherein the status report regarding the process of process of removal of enforcement over the government land has been mentioned. Stop. As per the said affidavit, the process is going on. And it will take some time to, and some time will take for completion of the said process. Full stop. Just after 8 weeks, but now on the next day, the latest factual report be filed on behalf of the DC, Kamrup Metro.
Deeply.
Deeply obliged.
Item 27.
Latest, on the next day.
May I please? Lord, this writ petition is preferred, my lord, against the orders. My lord, against the orders passed by the Central Administrative Tribunal, my lord, Guwahati, my lord, rejecting the claim of family pension to the petitioners, my lord. Petitioner number 1 is the widow on surviving widow.
Why do you seek a declaration from the competent court? Why don't you seek a declaration? Otherwise it would be very difficult.
My lord,
Otherwise it would be very difficult. Seeking a declaration from the competent court.
civil court, my lord. My lord,
Obviously, otherwise, who is going
issue
to?
is that, my lord, the first wife has died, my lord.
No, it may be, but ultimately you have to seek a declaration that yes, you are the wife of this deceased employee. Simply because she died, therefore you are entitled. That is somewhat very difficult for us.
My lord, as per railway pension rules, my lord, both the widows are entitled, my lord.
But whether you are really widow or not, that is the question.
My lord,
That is the question. Until and unless you substantiate or claim that you are the widow of the deceased employee, how they'll grant you the benefit of pension?
my lord, after retirement, my lord, my husband, my lord, has filed several applications for inclusion of my name, my lord. And
He understands that. But until
he has
and unless-
accepted, my lord.
Until and unless there is proof that you are the second wife of the deceased employee, how we can grant a particular this direction?
My lord, thinking is there, my lord.
You should seek a declaration from the concerned court. Then only you will be able to get the benefit. Otherwise, there is no proof that you are claiming that you are the second wife of the deceased employee. But as such, there is no proof.
Lord, in one order, my lord, by the Central Administrative Tribunal, my lord, the page 62, my lord, operative part,
Yeah,
is directed to, my lord,
page,
page 62, my lord, 61, last paragraph. Submission of the last council for the respondent number 2, directed to consider and dispose of the representation of this answer decision of the Honorable Madras High Court in D. Kurobama Supra as quoted above by passing an appropriate orders after affording the applicant an opportunity of being heard.
so this Honorable Madras High Court judgment says that anybody claim,
Second wife,
anybody's claim can be, it should be decided in his or her favor,
second wife is,
despite having the proof.
my lord, second wife is entitled, my lord.
That your whatever the representation pursuant to that has been considered.
Considered and it's
Rejected, my lord.
In view of the above facts, you cannot be assumed as a legal married wife for the purpose of family pension as applied for you. What is the proof you are legally wedded wife?
My lord. My lord, my husband representation, my lord, submitted annexure 34, my lord. Annexure, my lord, page 34, my lord. My lord, I had lead a conjugal life of 34 years with my deceased husband, my lord, and I had 5 children, my lord. And that be of them, my lord, the one judgment of the Supreme Court, my
Your
lord,
husband died when?
in the year 2017, my lord.
And you married to that person in
Marriage
1983.
1983, my lord. 25 to 1983.
So your children must have been now attained majority.
Yes, my lord. Last, my lord, the one unmarried daughter is there, my lord. This is the respondent number, petitioner number 2, my lord. She is entitled, my lord, above all, my lord.
Very difficult for us to give a finding that you are the legally married wife in the absence of any proof, sir.
My lord, one judgment of this.
Okay, having heard the non-consent of the parties for quite some time, we are of the view that matter requires consideration. Admit. No need to issue notice. These parties are already represented. Extend due courts.
Item 38.
In this case, my lord, the pleadings are almost completed, but in their affidavit in reply, he brought some new facts. I want to reply on that, my lord.
We can consider
3 weeks,
for
my
the High Court. Place some. For the respondent, place some time to file counter to date. Additional affidavit filed on behalf of the. Additional time wait for the granted after 8 weeks.
Must be.
Item 39.
We have challenge and notification, lordship, and the respondent file affidavit today itself.
It's being filed, lordship. I have already served copy. lordship.
Yes, but I have received copy.
What do you want?
Lordship, any other date, it is not in the record, lordship.
The counter affidavit filed on behalf, counter affidavit to the writ petition filed on behalf of the respondent state is not available on the.
Take from
It is filed today on. The
single bench.
office is directed to place the same on the court. And let this writ up the writ petition after 6 weeks.
Obliged, Lord.
Supplementary list, item 48.
The
Yes.
My lord, on the date when the impugned order was passed, the registered lease deed had been furnished. On the date of the modified application, only the notarized lease deed was furnished. The question is, my lords, under the scheme, what is the time for furnishing of the registered lease deed? If your lordship just have a look at the brochure, my lord. This, my lord,
What is your answer? So para number 20.
my lord, the court has held that at the time of the application, you have to furnish the registered lease deed. But the scheme of the policy, if your lordship just have a look, this is, my lord's dealer-owned site. If your lordship will see, the advertisement starts at 38 and at 50, we are concerned with serial number 365. Borhat. And your lordship may only mark DC. This is dealer owned. I shall show at 62. And what is dealer owned is, meaning, my lord, the land offered is developed and the pump also set up by the. If your lordship had page 50 DC, your lordship, it is in the column number 5, just after page 50. 50 foot of the page 365, Borhat. We are concerned with Borhat, my lord. Page 50, 50, my lord. Foot of the page 365.
Yeah.
My lord, so if your lordship sees in column, just after open, next column is DC, that is dealer owned side, that your lordship will find at page 62.
Okay.
My lord, your lordship will just have a look. DC is defined at page 62.
Dealer owns.
Dealers own, that is the land offered and superstructure will be developed by the dealer. Now eligibility criteria is at clause 4 at 62, and we are really concerned with Roman 5 in the following page at 63. Now there are 3 types of groups, my lords. First is who offer, my lords, the land or the long-term lease. Second is a firm offer, meaning you have an agreement with a third party who is willing to offer the land. Third is who does not offer any land.
You were placed in group 3.
Group 3, because I was first round, I was found that it didn't fall within the. So they have a right, because the group 1, there was no candidate selected of group 1, group 2. Therefore, in terms of this clause, you are again given an offer to offer an alternative site and 90 days thereof. But if your lordship sees at other condition with respect of offering land as under, and if your lordship sees, see the last, for dealer-owned sites, the applicant should ensure that the land arranged by the applicant is either registered in the applicant's name or leased in favor of the applicant for a minimum period of 19 years and 11 months as advertised by respective oil company before issuance of LOA as per the LOI. So it may not necessarily be at the time of the furnishing of the application. Not because, your lordship, there is a Supreme Court judgment also on this, my lord. Otherwise, for group 1 at page 63, you're required to give along with the application. But this I'm saying, my lord, because this is my lord.
Immediately, you have submitted the registered deed or lease deed or whatever it may be, that is after the date which they
They sought for it, they gave us a date up to 25th of July. We submitted before that. Impugned order is passed on 9th of August 2023. I had submitted the registered deed prior thereto. My lord, the whole issue is this, my lord. Furnishing of the registered deed is mandatory. Whether along with the application, it is mandatory or directory.
We will hear the matter.
My lord, there is one Supreme Court judgment in a Gota on what they say that the condition is mandatory in a similar, not exactly worded, but the along with application may be directory. If your lordship just have a look at the clause is at paragraph 2G. My lord has the Supreme Court judgment 2003-10 SEC 681. Just place your judgment. My lord has that judgment. The clause is that at G in the second paragraph, the applicant should furnish along with the application details of land for Godam, which he may or may make available for distributorship, considering the location of the land from the point of view of commercial angle. Applicants willing to transfer a land facilities on ownership long lease to Bharat Petroleum at rates applicable would be given preference. If the applicant after selection is unable to provide the land as indicated within a period of 2 months, because we also have similar cancellation 2 months, the allotment made to him will be cancelled. Now the issue is whether it is direct, and if your lordship just have a look at para 8. So far, my lord has para 8. So far as the requirement of instruction G as stated above is concerned, it does not appear to be mandatory. The purpose of furnishing particulars of land in the application is to enable the determination as to whether the specified place would accommodate the go-down facility and distributorship from a commercial. The requirement is mandatory, but satisfying the requirement at the stage of making the application is only directory. The particulars of such land can be made available even subsequent to the filing of the application, may even be subsequent to selection. The consequence of failure to make the suitable land available within period of 2 months from the date of selection is that selection would be liable to be cancelled. We also have similar provision at page 66. Because cancellation, you given another opportunity.
Party right then, no third party right has been created yet. I was the only selected in the draw plots. Cycle have to within time and hold again within 21 days.
Will hear. Will hear this.
Yes, my lord, only prayer would be, my lord, let it be in a shorter period of time. Public interest is involved. Public interest is involved in deciding the matter, so on a shorter day.
I heard the concept of the party. We out of the view, the matter requires consideration, hence admit. No need to issue notices, parties are represented, the respondents are represented through concept. List this petition for hearing in the month of July.
My lord, interim before the High Court was subject to outcome.
Whether they have any issued any fresh advertisement.
No, my not yet.
Deeply obliged.
Item 49.
May I please as a lordship? Lord, in this petition, my lord, basically we have challenged only the part of the provision of chapter 10 of the Assam Land and Revenue Regulation 1886 that it is not applicable in the area of the petitioners. my lord.
Applicable
My
to
lord.
the area of the petitioner, then
My
why
lord.
this petition is before the division bench?
Because, my lord, that particular part is under challenge, my lord, here. Otherwise,
Why?
because, my
Your
lord, the,
case is that your, this land doesn't fall in that,
no,
area.
that instruction, my lord, or the, in a series of litigation, my lord, pending before the learned single judge. Till date, my lord, the government has not come up with that notification, notifying the area that whether the
So
area,
that is there, that is
My lord.
altogether different challenge. Challenge it before the, you have already challenged that.
no, that is
Before the
under
learned
challenge, but
single
here specifically we have challenged the chapter 10, my lord, that it is.
On what grounds?
Because, my lord, the very purpose of the, my lord, introduction of the chapter 10 is for the upliftment of the primitive condition of the particular class of people, my lord. Now, my lord, in that area, there is no that class of people exist as on date, my lord.
So how the
That is-
provision is bad, sir?
My
That
lord.
is also a fact, a question of fact.
No, that
The
is,
provision is bad.
provision is, my lord, that apart, my lord, we have challenged the provision on the ground that this is amounts to an unconstitutionality is also there. Because the right to possess of the property, my lord, in the territory within the country,
And
my lord,
you just show this, that this petition is not hit by the constructive res judicata. Principle of constructive res
no,
judicata.
my lord, because this,
Because you have opportunity to challenge the same before
my lord.
filing at the time of filing of the writ petition before the learned single judge.
No, my lord,
Why
bec-
not challenge it?
No, at that time, my lord, this situation was not arisen, my lord.
The situation was very much there.
No, my lord,
They have
the,
issued some notices to you, you approach, ke sir, in violation of the Supreme Court judgment order. They have issued that, then
My
they
lord.
came with that, ke we have already determined what is their status.
that is there, my lord.
Then at this stage, now you find that it's very difficult to defend yourself before the learned single judge. You have challenged this.
No, my lord, because it is, my lord, it is always open to challenge, my lord. It is always open to challenge, my lord. It is always.
So what is this prayer?
Lord, the prayer, yes, my lord, the prayer part starts at page 112, my lord. Chapter 10 of the is unconstitutional in respect of application of the same in the area wherein the petitioners are now residing, my lord.
It's unconstitutional. What it says, sir?
Because, my lord,
On
now,
one hand, you are saying it is not applicable to
my
us.
lord.
So
No, my lord, it is not applicable, but the respondents are now forcefully applying that provision, my
then
lord.
it is always open for you to agitate before the learned single judge that since it is not applicable, how they can apply this?
My lord, we have already, my lord, filed a petition challenging the order of, challenging the notice as well as the, my lord, the.
On this ground,
My
that
lord.
chapter 10 is not applicable.
No, chapter 10, my lord, basically in this petition, we have challenged the chapter 10, my lord.
Sir,
That the,
here you have not challenged
My
the
lord.
chapter 10, you have simply said declare that the same, the chapter 10 is not applicable wherein the petitioners are now residing.
my lord.
You can very well agitate this matter before the learned single judge that this chapter 10 is not applicable.
Then my lord can remand this matter to the learned single
What
judge.
remand? Where is the question of remand? We have not even issued notices, sir.
No, my lord, we are not, I am not on that, my lord. If my lord is not, if I cannot satisfy my lord that this is a matter to be
This is
ad-
not
adjudicated before the
to
division
quash the
bench, my lord.
provision of one in respect of the
My lord.
same area wherein the petitioner, sir, this type of prayer.
No, my lord.
On
Satisfied,
one hand, you are saying
my
that
lord,
it is not applicable in the area where you are residing.
my lord.
And another hand, you are saying in respect of the set aside and quash the provision of chapter 10 of the Itata in respect of the area. So this is a prayer is self-contradictory, sir.
No, my lord, my intention is not that, my lord. My intention,
Intentionally, but
my lord,
seems your prayers are self-contradictory.
my
sir.
lord.
On one hand, you are saying it is not applicable. On the other hand, you are saying declare it that it is not applicable in our area. How can it?
Then, my lord, if I, my lord, make a my lord, submission that the prayer A and B, my lord, I am not going to press, my lord. Then the rest of the prayer can be adjudicated by the learned single judge, my lord.
So that is you already
My
there, your
no,
petition
that
is
is-
already pending.
No, that is not pending, my lord. This speaking order has been, my lord, what they have done.
No, no, no.
Initially, they have issued the notice in violation of the Honorable Apex Court order as well as the order passed by the, my lord, two orders of the Honorable Apex Court has been violated, my lord. And now they have issued the speaking order.
On this very ground,
My
you
lord.
approach the learned single judge. Okay, they have not done it. The learned single judge has passed an order.
My lord.
This that they without adjudication as per the Supreme Court, without adjudication of their rights.
My lord.
Pursuant to the direction given by the Supreme Court, the eviction notices are bad.
My lord.
Then they filed a response to it. Okay, we have already adjudicated and this order stated 6/12/2024 and another order was placed on record.
My lord.
Faced with this situation, now you have come with this writ petition. You amend your petition there, sir. Amend your petition in the before the learned single judge. That
My lord.
is, chapter 10 is not applicable in our area.
My lord, this can be remanded to single judge. also.
Remanded, there is the question of remand, it is not pending before.
No, my
us.
lord,
It is not
if-
the first time it is listed, sir.
No, that is correct, my lord. That is correct, my lord. If my lord can with an observation that as I am not praying with prayer A and B at this moment, my lord. So therefore, the rest of the prayer can be adjudicated before the single bench.
Very well, amend your petition before the learned single judge incorporating the rest of prayers, sir.
My lord.
That is the proper court. Again, to multiply the litigation, the
No, my lord.
multiplicity of litigation, one is pending and another is also.
Because, my
being
lord,
remanded, sir. Why should?
Because in the pending petition, my lord, we could not challenge the speaking order. What they have done, after the stay order has been provided in the, when we challenge the notice, then they have come up with an affidavit annexing all those
And
speaking
your
orders.
allegation is it is these whatever the adjudication is done are backdated.
My lord,
As a matter of fact, no adjudication took place at any point of time.
no, yes, my lord, when the notice was issued, they were without adjudication initially issued the
They
notices.
became smart
My lord,
thereafter and now they have passed the backdated orders.
backdated,
So,
that
sir,
is the
you
issue.
can
my lord.
very well demonstrate before the learned single judge these facts, sir.
Then my lord can remand the matter, but I am
Sir,
not,
Remand, where is the question of remand, sir? When we have
Sometime, my
this,
lord, sometime.
for all practical purposes, this is not pending before us, sir. We'll keep it open
my lord.
that you can raise whatever the grounds you have raised here before the learned single in the pending petition.
My lord.
That we can raise.
Because, my lord, if we challenge the chapter 10, my lord, then it will be again,
Sir, challenge
My-
the chapter 10 here on this ground, sir. This is, you are not challenging the chapter 10 in.
that is correct, my lord. My prayer is not
That it
my
is
lord.
declared that it is not applicable in the area. That is altogether different, sir.
Different, sir, different.
So
My lord.
you may raise this objection before the learned single judge. Or take a ground before the learned single judge, sir.
Can be done. Then, my lord, I am not pressing prayer A and B, my lord, before my
Yeah.
lordship.
After attempting to argue the matter for quite some time,
My lord.
learned counsel for the petitioner has submitted that he is not pressing the prayer number A and B
My lord.
made in this writ petition. However, writ petition, the learned counsel for the petitioner has further submitted that in respect of the remaining prayer, the petitioners may be allowed. E also will go.
My lord.
A, B and E कहते हैं ना?
No, no, my lord, E can be by the learned single judge. D cannot be, my lord. E can be, my lord.
Declare the area when the now residing is not an area required under that, and then. ये तो ये-
No. No, no, E to Pariva.
ये भी-
E can be, my lord, but the D cannot, my lord.
Only A and B, that's another,
My lord.
and rest of the.
Rest can be
prayers
adjudicated.
prayer number A and B made in this petition, the learned counsel for the petitioner has further prayed for granting liberty to raise the grounds, the remaining prayer to include the remaining prayers the learned counsel has further submitted that he may be allowed to withdraw this writ petition with liberty to seek the other prayers of this writ petition before the learned single judge in the pending writ petition number.
My lord, or I will file a fresh, my lord. File a fresh petition. That will be better, my lord. Otherwise, it will be, my lord. With that liberty, my lord can,
Before the learned single judge by filing appropriate writ petition.
my lord,
Dismiss with liberty as prayed.
my lord, my lord. Oblige.
Passover meter 22.
Yes.
Lordship, I don't have objection if it is stayed, Lordship.
If we don't have any objection
If the tender is stayed, Lordship.
you are for,
I am for respondent number 1, Lordship.
who is respondent number 1?
He used the writ petition earlier, my lord, he
Lordship,
challenged that.
I have gone through the
His
record. Lordship.
contention was very limited.
Who is for other side? It's better. You don't have any objection. We have objection. Why should we stay off?
Lord, so far, my lord, your lordship, give me a chance in regard to paragraph 28.
Who is for the state?
State.
State of Pune.
Exit itself.
Anybody is appearing on behalf of the state?
Huh?
Whether we have issued notices? in this
Yes.
No, my lord. No, this is
Notice.
Mr. D. Gogoi.
Even the writ petition, Lordship, the writ petitioner was that writ petitioner has objected that some of the documents were not submitted by the appellant. Lordship.
You have participated in the press secretary.
That instruction I don't have.
What's that?
Is 16th, 77.
Is this writ appeal along with the IA, along with the connected IA on Wednesday, while reflecting the name of Mr. D. Gogoi, counsel appearing for the respondent number 2
When?
counsel appearing for the excise department. Let us see.
Obliged.
For hearing, item 41.
Reservation. My lord, in this matter, there was a direction to ask my lord to furnish the copies of both the writ petitions. And in fact, my lord, the copy of the writ petition filed by the respondent number 6, my lord, the certified copy we have got only today, my lord. So what I pray is, my lord, we'll file it by tomorrow, my lord. Let it come any day next week.
July.
My lord, may I pray for fix of a date because my lord,
July, man. Whatever the date in July.
because my lord, my appointment has been cancelled, my lord, in terms of this interim order.
That's why only July.
Item 42.
Another bench. Circle.
Item 43.
Yes, Mr. Who is appearing for the private restaurant?
I think my friend appears. I'll if you have on behalf of the petitioner referral number. Here, my lord, before going, it is my prayer and may not be edition, your lordship due permission. Because our validity period up to 25/10/2025. Once your lordship was pleased to pass an order directing to go for petition, but health department says it is too early because you have to apply for 1 month before only, so that only we can consider for permanent addition. That is, and now, my lord, only hardly 3 months or hardly 4 months are left. Because if your lordship direct, my only submission and anxiety, my lord, on behalf of petitioner, let him go for once for your lordship direction for final review. Because lordship is pleased also, I am feeling, suppose his gate is as per judgment of the honorable single judge, I may be effective up to 25/10 only. Thereafter, I have to go. That is why finally, my prayer before lordship, if lordship directs the health department, I'll appear before him, then I'll go for final review, Miller. Once final review, he will go for final review. Because otherwise, 3 months are different. Or otherwise, it may take that away.
Certificate is valid till 25/10.
25/10/2025/10. Because before that,
We'll list it in September.
but before that, my lord, I may be September, because if,
But 1 month before you have to apply, na?
no, that's why.
But the
before
problem is, my
now-
lord, problem is, the advertisement itself says that the disability has to be acquired prior to the date of the
but
last date of submission. That clause, my lord, that is not under
No,
challenge.
if so, my lord,
Chance if you.
yeah, if so, my lord,
Yes.
I'm ready to go for argument, whichever it is manner, but I may be allowed to go for an argument, because my today's submission is there, the lordship pass an order, let him go for petition, only this observation, go for final legal review for this, within 1 hour. Or,
Before the time, how can we grant you this relaxation?
no, relaxation is not there, my lord, they will, the lordship direction taken, but they can, lordship may direct.
The time, how can we give a direction? Until and unless the time is passed, how can we give it?
No, that is why I am before lordship. Otherwise, lordship may hear the matter, entire matter, whatever manner it is goes.
Okay, we'll hear on the next day.
Next date will that way here. Next date will not, it should be because 25/10 only it is there. When,
After 2 weeks, okay.
my lord?
After 2 weeks, we'll hear finally.
Acha, my lord, that's oblige. Date may be fixed, my lord, so date.